Hello everyone and welcome to the second of our video tutorials on Occupiers Liability. Today we're going to be looking at the Occupiers Liability Act 1984. Just to remind you that there are two statutes which govern the law on occupiers liability, the 57 Act, which relates to lawful visitors, and the 1984 Act, which relates to persons other than the occupier's visitors, i.e. trespassers. In our last video tutorial, we concentrated on the 1957 Act, but today we're going to be looking at the 1984 Act. The 1984 Act provides the basis for the duty that an occupier has towards those who are not his lawful visitors. That's going to include trespassers, i.e. those who lacked permission in the first place, as well as people who were initially expressly invited to be on the premises, but they've gone beyond their permission and they've become a trespasser. You can see here that there is a lower level of protection for trespassers given than is given to lawful visitors. And a trespasser can only claim for death or personal injury. They can't claim for damage to property. So under the 57 Act, the claimant can claim for damage to his property, but not under the 84 Act. It's useful at this point to just consider what the law was before we had the 1984 Act for liability for trespassers. These two cases should actually be familiar to you from when we looked at the topic of judicial precedent. So Addy and Dumbreck, you can see here, was an old case, 1929, so years before this 84 Act. And this was the case involving a little boy who'd crawled through a hole at a playground fence and crawled onto a railway track where he was electrocuted and paralysed. Now, in that instance, the little boy was a trespasser because he shouldn't have gone through the fence and he shouldn't have been on the railway line. But the railway company should have arguably kept that fence maintained. But they were held not to be liable because at that time, the only duty to trespassers was not to inflict harm willfully. So basically, because they hadn't thrown him on the track, they weren't liable for his injuries. Now that's seen as pretty harsh. And if you recall, the House of Lords had to reconsider this position in the 1972 case of the British Railways Board and Harrington. The House of Lords in this case took the unusual step of overruling the previous decision in Addy and Dumbreck, and this was the first major use of the practice statement to depart from a previous decision. But the House of Lords at this time decided that occupiers owed a duty of common humanity to trespassers. So they recognised that times had changed since 1929, and now we recognise that even though, okay, a trespasser shouldn't be on a particular premises, that we still owe them this common duty of care to try and ensure that they're not going to be injured. So this duty of common humanity. Whilst I strongly agree with this decision, there are a lot of people out there who do take a very rigid stance and sort of will probably prefer the old law in Addy and Dumbreck. There is a sort of general view that if you're a trespasser, well, it's your own fault and we should be able to hurt trespassers. And if they come onto my land, I would hurt them. That seems to be an attitude that you hear quite often, particularly in the media. An Englishman's home is his castle, and you should be able to take the law into your own hands and do what you like to trespassers. And that's kind of what we saw in criminal law with self-defence and the way that homeowners are now able to use disproportionate force. So lots of people don't really like the fact that we owe a duty to trespassers, which I disagree with. But what we need to bear in mind is that the duty under the 1984 Act is nowhere near as protective as the duty under the 1957 Act. So if we have a look at Section 1, subsection 3 of the 84 Act, it says that an occupier will owe a duty to a trespasser if the following three situations apply. So firstly, our occupier must be aware of a danger or has reasonable grounds to believe it exists. He knows or he has reasonable grounds to believe that a trespasser may come in the vicinity of the danger. And 3, the risk is one in which all of the circumstances of the case, he may reasonably be expected to offer some protection. And under section 1, subsection 4, the duty owed to trespassers is just to take care to see that they are not injured on the premises. Now, that is a different standard to what we saw under the 1957 Act. So if we have a look at how this duty under the 84 Act differs from the 57, under the 57 Act, under section 2.2, the duty is to keep the lawful visitor reasonably safe. Whereas under the 1984 Act, the duty is to ensure they are not injured. That is a lower standard of care that we are owing to trespassers. And this is illustrated by this handsome chappie, Lord Hoffman, here in this quote that I've given to you. So Hoffman says, Parliament has made it clear that in the case of a lawful visitor, one starts from the assumption that there is a duty, whereas in the case of a trespasser, one starts from the assumption that there is none. So the point I'm trying to make here is that although people are wary of there being a duty of care to trespassers, it is a lower standard, and as Hoffman is saying, we are starting with the general assumption that we don't owe a duty, and it's only if certain criteria are met that a duty will be owed. We're going to have a look at the case of Jolyon London Borough of Sutton here. This is a case that we looked at in the case of negligence. We also looked at this in the 57 Act video tutorial as well. So this was a very important House of Lords case. And if you recall what happened here, our council failed to move an abandoned boat that was left on a park for 2 years. And children were known to regularly play on the boat, and it was clearly a potential danger. And on one occasion, 2 14-year-old boys were playing with the boat, and they did something quite unusual with it. They jacked the boat up, and one of them crawled underneath it, I don't know, pretending to be a mechanic or something, and the boat actually fell on top of them. And the boy was seriously injured. Now, the issue was there liability under the Occupiers Liability Act? And the House of Lords allowed the claim. Now, when you think about this, this relates to trespassers because the boys should not have been on this boat, okay? But they were injured on it, so we're considering whether the council owes them a duty. So the House of Lords allowed the claim and said that although the way in which the boys were injured was unusual, i.e. climbing underneath it, the council knew that children played there and that children were likely to meddle with the boat. So I'd like to just switch back to this previous slide now that we've looked at Jolly so that we can consider this. So if you think about the council in Jolly and Sutton, the council was aware of the danger because they knew that abandoned boat was on the park and it had been there for 2 years. They knew or had reasonable grounds to believe that children often came in the vicinity of the danger, and the court held that the risk of this dilapidated boat was one in all the circumstances that they ought to offer some protection. And under 1.4, the council owed a duty to see that children were not being injured. And that would have been quite simple, just remove the boat. If we have a look here at the case of Tomlinson and Congleton, we mentioned this case when we were looking at the 57 Act, but it's actually a trespasser case. So it was relevant to the 57 Act because it had warning signs in it, so it relates to the rules on warning signs, but we can look at it under the 84 Act. So in this case, Tomlinson ignored warning signs signs and dived into a lake which was quite shallow, and this left him tetraplegic. Now, Tomlinson was a trespasser when he jumped into the water, so the 1984 Act applied. So he knew he wasn't allowed to swim in the lake, he'd ignored all the signs, he's clearly a trespasser. He knew he was not allowed to go into the lake because he'd seen the signs, and the council also had some patrols where people would go around the lake and tell people not to swim and not to dive. Now, Tomlinson was trying to sue the council under the Occupiers Liability Act for his injuries. And the court said that the council were not liable because the risk arose from Tomlinson's own voluntary action rather than the state of the premises. And they said that the risk was obvious. There were lots of signs explaining that the lake was very shallow and it was very dangerous to dive into. He was an adult and that risk would have been obvious to him. And the council couldn't be expected to take any further steps than they already had. So he was unable to claim in that situation, which I think seems fair. And this case also illustrates the defence of volenti non fit injuria, because when he ignored the signs, the law said he was volenti, that he was consenting to run the risk of harm. And that leads us on quite nicely to the defences that are available to the Occupiers Liability Act 1984. So just like with the 57 Act, an occupier can give warnings of the danger and that can discharge the duty, and that's under 24A. And we saw in the case of Tomlinson and Congleton that warning signs were given and they did discharge the duty. Another defence is volenti non fit injuria. Again, that was illustrated in the case of Tomlinson and Congleton because when he ignored the signs and jumped in the lake, the court said that he was volenti, he had willingly accepted the risk. The other big defence is contributory negligence. So it would be possible to find the occupier liable under the 84 Act, but then just reduce the claimant's damages in proportion to their own stupidity, if you like. So we can apportion the losses. And the final case I want to talk to you, which links on to that contributory negligence point, is the case of Revel in Newbury. And in this case, our defendant was sleeping in a shed with a shotgun because he'd been experiencing frequent break-ins and he'd cut a little hole in his shed door and he was planning to shoot a burglar. So the victim came along, was going to go through the shed, and our defendant shot him through the hole, and the victim brought a civil action. And he raised an ancient defence called extirpi causa, and the judge actually rejected extirpi and found that the defendant was liable for damages, but they were reduced by a whopping 2/3 because of the victim's own contributory negligence. So extirpi causa is a really old defence, and it states that a claimant will be unable to pursue a legal remedy if it arose in connection with his own illegal act. So basically our defendant was saying because the victim was doing something illegal, i.e. burglary, he couldn't then sue for the injuries that he sustained. But you can see that the court rejected that old defence. It's not really liked at all now, and instead applied contributory negligence. But you can see massively reduced the damages here. And under the 84 Act, the court emphasised in this case that you cannot treat a trespasser as an outlaw, and you have to ensure that they don't suffer injury on the premises. And I'd just like to end by having a look at the summary slide here. So the Occupiers Liability Act 84, we know who an occupier is from Wheat and Lacon. We know what premises are. They were defined in the 57 Act, section 13A. And we've looked at today the duty to trespassers, which is lower than to lawful visitors. And we've looked at these key cases on that.